This Honorable Court of Tennessee is now in session. You may be seated.
Good afternoon. Just a quick reminder that our oral arguments are streamed live. So whatever you say or whatever we say is out there, never to be called back. Call the first case, please.
Morgan Ashlee Hood versus State of Tennessee.
We'll hear from the appellant.
Good afternoon. I'd like to reserve 2 minutes for rebuttal.
2 minutes, that'll be fine.
Yeah. And may it please the court, I'm Josh Walker of the Knoxville Bar. I'm here for the state of Tennessee. And I hate to start out with admitting an error, but I realized when I was getting ready for this, in my reply brief, I have some incorrect citations on the last page of that. So if it's all right with the court, I will submit an amended brief with the correct citations after this.
That'll be fine.
But I do apologize for that.
Yes.
Okay. We're here today seeking reversal of the commission's judgment, and we're basically taking issue with the commission's factual findings. Since this is a factual issue and there's been a dispute in the briefs as to the standard of review, I thought I would just talk about that briefly. Rule 13D sets that out for cases tried before the court without a jury, which is, of course, how the commission operates. And it's a de novo review with the presumption of correctness of the facts found unless the preponderance of the evidence is otherwise. So I know there was some difference in the briefs, but I don't think there's much question about that, but certainly I'll be willing to answer any if the court has them. But looking at the facts of this case, there are two main issues, that the state raises. Number one, the commission should not have found liability in the first place. And number two, if liability is appropriate, the non-economic damages awarded were too high. I want to concentrate mainly on the liability portion. The facts of this case involve a young lady who fell in a dormitory suite bathroom at the University of Tennessee. The way these rooms are set up, and there is a diagram of the floor plan that was Trial Exhibit 5. It is in the record if the court wants to look at that. But the way these rooms are set up, there's an outer door at the hallway. You walk in, there is a commode on one side and a shower on the other. That's the bathroom area for the 4 suite mates. And then there's a door on either side in front of you after you walk in, and there's sleeping quarters behind each of those doors, and 2 people in each of those quarters. And the claimant lived in 510 CD. It was on the 5th floor of South Carrick Hall, and she returned to her room, slipped in some water, and fell, injured her arm. And it's her assertion that this spill was caused by the housekeeper who was cleaning the 5th floor that day. Now, there are 2 main reasons that it is not possible that the housekeeper created this spill. The first is the housekeeper testified that it took her 20 minutes to clean this. She also leaves her cart out in the hallway when she's on the floor working in the rooms because it won't fit in one of the rooms. The claimant testified that she was in her room for only about 15 minutes. She went in, came back out to go to the bathroom, and this fall happened. She also did not see any cart or any evidence of the housekeeper when she came back to her room. So this would mean that within this 15-minute period, the housekeeper had to wheel her cart up to the floor, go in and do a 20-minute job, and then disappear completely when she still had at least one more room to clean that day in less than 15 minutes, and that just can't happen. The other timing issue is that the claimant, now there were a couple of versions of when she fell. It was either 1 o'clock or 1:20, whether you take the pretrial statements or the statements that were made at trial. But that's when she said she fell, and the housekeeper testified that she used the same pattern for all the floors in the dormitory were the same.
I'm sorry, let me interrupt a second. Just pause this time a second for a minute. I hate to ask this, but could somebody go close our back doors back there? I'd appreciate it because the noise.
Thank you.
May I continue, Your Honor?
Well, wait till we get the doors closed.
I'm trying to find the pause button.
Well, however time it runs, make sure he gets his full time. sorry, but it was, the doors open, the traffic, I'm easily distracted. I won't speak for them.
I share that, Your Honor.
I wasn't distracted at all. I was paying attention and didn't even know anyone was back there.
All right, go ahead, please. Sorry.
But this fall, it was testified that it was either 1 or 1:20. The housekeeper testified she used the same pattern each day that she did this. She would get up on the floor about 9:20. She would do the RA's room first, unless the RA said come back later. She would then start on the long side of the hall, work toward the middle, and then go to the other side, the other end of the shorter hall, and work toward the middle. And the claimant's room was in that short hall, kind of next to the middle of the hall, so it was one of the last rooms that she would get to each day. She had a lunch break, 2 shorter breaks, and she said, I would get to this room at about 2:15 or 2:20 after my afternoon break. So she wouldn't have gotten to the room until after the claimant had fallen.
Excuse me for interrupting, counsel. Did the trial court make credibility determinations?
The trial court did, and we do take issue with that as well. I can go ahead and address that now.
If you would,
It's,
please.
well, first off, the housekeeper testified by deposition. And as I understand the law, this court gives no deference to a credibility determination by deposition, because the court here can judge that just as well as the trial court can. And also, what he did question about the housekeeper's testimony was that she had given her deposition 2 years after the fact, so he raised that as an issue that her memory might be suspect. But she had testified in that deposition that about a month after this happened, she was informed that it happened, asked to write up some sort of incident report about what she did that day in regards to cleaning the floor, and she did that. So she wrote down what happened within a month of it happening. And plus, this was a repetitive job that she had done on a daily basis for about 2 years, and the same pattern every day. So I think she had a pretty good handle on when she got to where on the floor. As far as the claimant's credibility, now that was a live witness. The issue we have there is twofold. Although the commission just says, I find this to be credible, no reason was ever given. And in the case, I believe it was the Haskins case cited in the claimant's brief, the court there talked about how there were specific statements about the affect and the interest of the witness affecting credibility. There was nothing like that here. We also take issue with the credibility of the claimant because she changed her testimony in trial. And that's what I was talking about with the time of the fall. 5 times before trial, she said she fell at 1 o'clock. On an incident report she filed 3 days after the fact, in her complaint, in her sworn interrogatory responses, in her sworn deposition, and then she admitted 1 o'clock in response to an undisputed fact in a motion for summary judgment. So we had that 5 times. At trial, she testified that it was a different time, that she, instead of falling at 1 o'clock, she got back to her room at 1:05 and then fell 15 minutes after that. Of course, that's contrary to what she had said multiple times before, contrary to what she had said 3 days after it happened. And this happened for the first time 2.5 years, or more than 3.5 years after the event, because that's the trial. This was in 2019. The trial was in early 2023. Of course, we objected to that. The commission overruled that objection for a failure to supplement the discovery and let that in. But, the main change in this, she said she recreated her day, and she remembered that she waited in line at Chick-fil-A for 20 minutes. Now, maybe somebody can remember how long they waited in a fast food chain line 3 years after it happened. I know I couldn't. And also, Chick-fil-A, of all places, I don't know if they're good or bad, but they sure can run people through there awfully fast. 20 minutes is a long time to wait in a Chick-fil-A line. But the other issue is the recreation of the day. She couldn't tell it the way she intended to the first time. If you look in the transcript, she originally says, I got back to my room at 1:15 and fell 15 minutes after that. And then immediately she's asked a series of leading questions that backs that back up to 1:05. So if she really recreated her day, and it was credible, I think she could have told it correctly the first time she told it, but that didn't happen. But that's the credibility issue that we've raised, Your Honor, regarding that. Well, and also, as far as the claimant's testimony, Ms. Hardy testified that when she did mop the floors, it was a wrung-out, damp mop. The floor might be slightly wet for about 5 minutes, and then it would dry. The claimant testified that when she fell, the water was either completely wet or saturated. I can't remember the exact term she used. That is in our brief. And that her clothes were completely wet to the point that she had to change them. And I just don't think that lines up with common experience.
Well, I mean, was there any proof? I understand what the housekeeper testified, that what she does, but other than that, was there any proof contrary to the plaintiff's testimony that it was wet, fell so wet that I had to change clothes before I went to the ER?
No, I don't think there's any testimony, but I'm saying.
And the trial court believed her on that,
Well,
certainly.
The issue there is, Your Honor, it's not how wet it was, it's how would it get that wet? It's not going to get that wet from.
Well, thank you, that was where I meant to go to start with. Is there any proof that anybody else was present?
We don't know. She testified that nobody else was present, but she also testified that she went in her room, closed the heavy wooden door, put on a pair of headphones, and was listening to TV through the headphones. And she said if somebody was cleaning out there, I couldn't have heard them. She also testified that the outer door didn't always lock. She didn't testify that she locked it that day. She did say that her suite mates weren't there, but the suite mates didn't testify, and she has no basis to say that because she's behind a closed door.
Well, did anybody take the suite mates' depositions?
No testimony from roommate or suite mate. Now, her roommate would have been in the room with her. She would have known if she's there. But the suite mates, and with the door not locking, somebody else who lived on the hall could have come in there. And and that's one of the things the commission, when it talked about that door being locked, it didn't use the words res ipsa or exclusive control, but it got awfully close. That's what it sounds like when I read it. And I just think that's something else that was missed. There's no proof that nobody else was in there, other than her statement that she has no basis to make because she was holed up in a room with headphones on. Let's see. So that is, I think that's pretty much it. I mean, we've set forth in the brief on the liability issues. There is the timing issue. There's the issue with the testimony that the only other thing, her testimony also lines up the fact that she never saw or heard a housekeeper supports Ms. Hardy's statement that she didn't get to that room until after 2:15 that day, after her break. Because, anybody who's been to a hotel has seen the housekeeping services. They leave their carts sitting out there. It's obvious when they're working on the floor. And she didn't see that. She didn't see a housekeeper. She didn't hear a housekeeper. She didn't hear anybody cleaning, flushing a toilet right outside the dorm room, running a shower right outside the actual bedroom part of the suite. Didn't hear any of that. So there really was no proof that the housekeeper was there, or at least her recollection lined up with the housekeeper not being there. Very quickly, I want to turn to damages. I've laid that out. I think the non-economic damages are excessive, but I think the biggest indicator of that is the commission awarded $20,000 for scarring and disfigurement. And what the claimant had as far as scarring, she had a surgery on her elbow, and she has a small scar on her right elbow. She's not a model. She's not, doesn't have a scar on her face or anything like that. She's got a small scar on her elbow. And she was awarded, more than the price of a new car or tuition to go to lots of universities. So I think that's the best indication that the non-economic damages were excessive. And I've set out other reasons for the other categories, but my time's about to expire, so I'm going to stop here. Thank you.
All right, thank you. You have your time for rebuttal. Hear from the appellee.
Good afternoon, Your Honors. Allie Toll here on behalf of Morgan Hood. I want to also candidly admit that I have made a mistake as well, and that is in citing the standard of review. We do agree with the state of Tennessee that the de novo review with the presumption of correctness is the correct standard. And we do rely heavily on that presumption of correctness because we feel that the trial commissioner got it right. When you look at the aggregate proof, it's entirely possible that the claim, as Ms. Hood stated it, is what happened. I want to start first with what we just talked about, the damages that were imposed. Ms. Hood did undergo a surgery. She does have scarring surgery. But the primary permanent injury she testified to was that she can no longer extend her arm straight out like I'm doing now. Her arm can only extend like this. And to have a permanent injury where you lose the function of your arm that you had prior to a fall is certainly an injury that warrants the $187,000 that the Claims Commission imposed. We argued that it was closer to $287,000, and the commissioner, in his judgment, reduced what we were asking for. But certainly, with a devastating injury that Ms. Hood testified to, she had to endure over, I believe, a week and a half of pain and suffering to allow swelling to go down before her surgeon could even go to the point of offering her surgical care, had to recover from surgery, go through painful physical therapy, and is now left with a permanent deformity of her arm. The damages aren't excessive when given those facts. Now let's move to the liability. For a premises liability case, we can either argue that the defendant created the dangerous condition or that they had notice of the condition and they either knew about it or it existed for such a period of time that they should have known about it. We argued that the defendant, through its custodian, created this dangerous condition. How can we tell that this condition was created by the state of Tennessee's employees? Ms. Hood testified that the floor was just not wet. There wasn't just a puddle. The entire floor of the dormitory suite restroom, when you entered it, was saturated. So much so that she had to change her clothes before she could go to the hospital. This solution on the floor, she testified, smelled like a cleaning solution, and importantly, just like it smelled every time the restroom was cleaned in previous weeks when the custodian would come. Now, those facts alone are sufficient, we submit, to show that this condition was created by the custodian. There is a dispute as to time. Ms. Hardy may not recall times correctly. Ms. Hood may not recall times correctly. But if we set all of that aside, what we come back to that we know is there was a cleaning solution or a solution on the floor that smelled just like the cleaning solution of all times past when this floor had been cleaned. Ms. Hood testified none of her suite mates were present, and she did not.
How could she know if her suite mates were present or not?
She testified she did not see any suite mates present from the
she didn't
time
see
that she
anybody.
arrived until the time she left and went to the hospital.
Okay, so she didn't see them, but she's in her room with the door closed,
Correct. So
wearing headphones.
yes, Your Honor. She comes back from her class. She eats her Chick-fil-A with her headphones on and the door shut, and then she exits to go to the restroom, and when she does, the fall occurs. There is no certainty that someone else did not come in there because she does have that door closed, but from what she can see, and more importantly, taking into account the type of wetness that was present in that floor, by a preponderance of the evidence, or more likely than not, the solution on the floor was cleaning solution and not something spilled by a suite mate or anyone else that would come into the room. She also testified she did not spill anything upon entering the room. With regard to the discrepancies in time, Ms. Hood did explain why she previously said 1 o'clock. She testified that after her deposition, she went back and actually pulled her schedule to determine what time she would have gotten out of class, and she calculated typically how long it would take her to walk to Chick-fil-A. And I don't have the transcript right in front of me, but I don't believe she waited in, or said she waited in line 20 minutes at Chick-fil-A. I do submit that most of the time they are quite efficient with their services, but I laughed and looked back at my legal assistant because on our way up in Lebanon today, we spent about 30 minutes in the Chick-fil-A drive-thru and commented how unusual it was. So things happen. but she also testified how long it would take to walk from Chick-fil-A back to her dorm room, and looked at the medical record as to the time she arrived at the hospital, calculating what time or how long it took for her sorority sister to pick her up and how long the drive would have been. So after the fact, she tried to be more definitive. The trial court believed her. The commissioner found her to be credible when she was there testifying in front of him. And again, there is a presumption of correctness that he got it right. Importantly, Ms. Hardy, the custodian, testified that procedure for the University of Tennessee requires her to place a wet floor sign out when she has mopped a floor. She did not do that. Her procedure also requires that she wet mops the floor and then she dry mops it. We can assume that Ms. Hardy may have a tendency not to follow the rules. She didn't do it in the instance where she was supposed to put the wet floor sign out. And if we believe Ms. Hood, the floor was so wet that it saturated her clothes. Therefore, it follows the floor was not dry mopped after it was wet mopped. If she is not going by all of the steps that would have her cleaning a full room in 20 minutes, then it's entirely probable that she can go through cleaning this entire 5th floor on a Tuesday, the day when 5th floor is cleaned, and complete her task before her 2 o'clock break. And it follows that if she did clean Ms. Hood's floor and then leave the floor to take her break immediately after cleaning Ms. Hood's dormitory, her cart would not have been there for Ms. Hood to see. But what was left behind was the smell of cleaning solution like it was every other week. Bear with me, Your Honors, while I look through my notes. I want to make sure I haven't missed anything that I deemed important. The question we have is, which party's favor does the aggregate evidence fall under this de novo review with a presumption of correctness? We submit the facts that are before the court prove, more likely than not, or more probably, that the Claims Commission got it right. Ms. Hood fell on cleaning solution that was left behind when the custodian mopped the floor and was injured with a permanent injury to sufficiently justify the damages she was awarded. Thank you.
Thank you. Hear from the appellant rebuttal.
Thank you, Your Honor. I would just like to point out at first, I think the speculative nature of the claimant's proof is shown by the argument, heard lots of, if this happened, then this could follow. And it's possible that this could happen. And I think one of the first things that was said in the claimant's argument was it's entirely possible that this happened the way Ms. Hood testified. Well, that's the whole issue. Possibility is not enough. It's got to be probable. I'll agree there are things that are possible, but you got to prove it to a probability. About the permanent injury to the arm, Dr. Weichert, and that's actually my error in citations, I messed up where his deposition is, but he testified that he was very surprised at how well she did, that she had done so well with so few visits to physical therapy, and that she had pretty much, I mean, it's not a complete, she can't perfectly straighten her arm, but I don't think it rises to the level of a permanent deformity, but the court can certainly read Dr. Weichert's testimony and see what you think about that. The smell like the cleaning solution, that is one thing I forgot to mention when I started. She didn't say it smelled just like it had been cleaned until trial. That was another thing that changed. In her deposition, and she was asked about this at trial, she said it smelled like some sort of cleaner, and what's it smell like? I said, well, does it smell like Pine Sol? Yeah, it smells like, when I suggested it, she said it, but if it smelled just like every other time the housekeeper had cleaned it, seems like that'd be an easy thing to say in your deposition. The recreation of her day, these distances, these times, all that sort of stuff, pretty sure she had that down cold 3 days after this happened when she filled out that form and said 1 o'clock. And then the wet floor sign with Ms. Hardy, she readily admitted that she didn't do that. Admitting that you did something that you didn't do something you were supposed to do, I think bolsters your credibility. I mean, if she's going to make up some story about the timing and all that, why wouldn't you throw in there, yeah, I put the sign out, of course I did. The other thing, Ms. Hardy, as a state employee, is absolutely immune. She can't be liable for this. So she has no interest in this at all. It doesn't matter to her. So I think my time is up, so thank you.
We, court's thanks to both counsels, both sides. We appreciate your arguments. I think you set the issue squarely out in front of us. So thank you.